We are pleased to present our program today, The Assault on Independent Contractors, which features two senior partners with Atkinson, Andelson, Lawyer, Rude, and Romo. Atkinson, Andelson, Lawyer, Rude, and Romo is a full-service law firm with 150 attorneys in 8 offices throughout California. With over 35 years of uncompromising commitment to high-quality legal work and providing consistently practical management solutions to its clients, AALRR has earned a reputation as one of California's leading law firms and represents both private and public sector clients, with emphasis in the areas of employment, labor, construction, education, real estate, general business and business litigation, corporate, taxation, and immigration. Please visit aalrr.com for additional firm information. Thomas Lenz is a senior partner handling all aspects of labor and employment law for the firm's Cerritos and Pasadena offices. He heads the firm's traditional labor and National Labor Relations Board practice and works with employers in all major industries across California and the West. He is currently a member of the Executive Committee of the Labor and Employment Section for the State Bar of California. Tom has been named to the top 100 labor attorneys in the United States by Labor Relations Institute, Inc., a leading industry information source. He has also been named a lecturer in law at USC Law School. Cindy Arellano, head of the business and tax team of Atkinson Andelson, is a senior partner in the firm's Cerrito office. Her practice focuses on employee benefits and executive compensation, qualified and non-qualified deferred compensation and retirement plans, health and welfare benefit plans, ERISA, tax audits and other tax controversy matters, and MBE, WBE, DBE certification. She also works with nonprofits, including educational foundations, auxiliary organizations, charitable organizations, and trade associations, and represents clients in general corporate transactional matters, business formations, compensation structuring, and mergers and acquisitions. Now we are pleased to present The Assault on Independent Contractors.
Hello everyone, I'm Tom Lenz, and it's a pleasure to speak with you today about independent contractors. This is an issue that comes up with many businesses we deal with throughout California and elsewhere. And it's an issue that is quite prevalent because of many misconceptions about whether employees are in fact independent contractors or vice versa. Legal issues have arisen in many different places, and that has led to developments we will be discussing here in an effort to educate you on what to be aware of and how to deal with it. The concept of misclassification is at the heart of independent contractor issues. Misclassification is often a claim raised against businesses who assert that individuals are improperly considered to be independent contractors when they are in fact employees. And this can come up in a variety of ways in terms of wage and hour, taxation, and other sorts of laws and court proceedings, agency proceedings. And businesses are often defending themselves saying, wait a minute, these individuals are independent contractors because that's the arrangement that we reached when we established the relationship. That's a relationship they've worked on for some time. So there's often a disagreement in terms of whether there's been misclassification. There are a series of rules we will be talking about in terms of how the analysis is performed and how these issues are resolved. Why should we be concerned about classification or misclassification issues? It's because government enforcement and investigation of these issues has increased, and businesses are increasingly under the microscope. The Obama administration has resulted in more enforcement actions against employers who are accused of misclassifying individuals. The Department of Labor, DOL, as we often refer to it, has entered into an agreement known as a Memorandum of Understanding with the Internal Revenue Service and a number of states in order to collaborate and to try to stop misclassification. And then at the state level, we have different states taking different positions based upon the laws they enforce. Where we are in California, for example, there are increased penalties for misclassification of workers as independent contractors. We see this in California's labor code, and we see the labor code enforced at a number of levels by different agencies. In terms of enforcement issues, the federal and the state government are pursuing misclassification claims against employers and in support of individuals they view as misclassified. Many times, attorneys who represent employees will make claims that we defend that the individuals who are considered to be independent contractors are misclassified, and this is often in support of wage and hour claims. It's in many instances an opportunity to receive a large payout because of the penalties available under the law. So we think it's very important that you be aware that businesses who use a large number of individuals considered to be independent contractors can be quite vulnerable if they are not following the current legal guidelines. So why would a business consider classifying someone as an independent contractor? What are the perceived benefits? There are a number of them. Businesses like the fact that with an independent contractor, you do not have to withhold income taxes, nor do you withhold or pay Social Security. You do not withhold or pay Medicare taxes. There are no unemployment taxes. There is no workers' compensation cost. And many times, the individuals working for a particular business request independent contractor status. And you can see from these sorts of benefits that the economic burden on a business is lower, and the amount an employee or independent contractor who is misclassified receives on the paycheck is going to be higher. So there are more benefits perceived in terms of use of independent contractors. There is immunity from most employment laws because someone considered an independent contractor is not going to have the rights that would be extended by the law to an employee. This could include minimum wage, overtime, record keeping, and anti-retaliation provisions. Unions are quite interested in the misclassification issue because independent contractors are not employees under federal labor law. They are not allowed to organize, form, or join a union the same way that an employee would be. Independent contractors are immune from claims of civil rights violations. Independent contractors do not have protection under age discrimination or race discrimination or disability discrimination law. So again, this is an issue where the employer believes that they are immune from attack under these issues, and the workers, if they are misclassified, are denied the protection of these laws. Additionally, the perceived benefits are that an independent contractor is not covered by ERISA, the federal law which governs employee benefits. So for health and pension and other ERISA regulated benefit plans, they would not be eligible if they are independent contractors. So For some employers, using independent contractors can be a factor it can be an effort to avoid wage and hour, payroll tax, benefit, and other obligations that might otherwise be required for employees. Now, Cindy's going to talk about some of the risks.
Hello, this is Cindy Ariano. So Tom has talked about the benefits to businesses and to workers in using independent contractors and in having the independent contractor designation. Let's talk a little bit about risks associated with using independent contractors. You're typically going to see those risks arise when your company or your business gets audited by a federal or state agency such as the IRS, your state employment taxing agency, the DOL, or your state agency that handles wage and hour claims. My practice involves a lot of tax controversy work, and I deal with a lot of employment tax audits, and we are seeing a significant increase in employment tax audits, both federal and state, with the focus of those employment tax audits being on the worker classification issue. It's not surprising. The worker classification issue and tax audits where workers are found to be misclassified generates quite a bit of revenue for federal and state taxing agencies. You also, though, will see audits and agency scrutiny from the DOL and from the NLRB on independent contractor worker misclassification issues. We know where the issue may arise. Let's talk about what liabilities you as a business owner may be facing. I think most of my clients, when they start using independent contractors, take into account, to some extent, the potential liability of employment taxes. It's generally understood that if you misclassify a worker and you're subsequently audited and that worker is reclassified, that you as a business will be responsible for paying the unpaid employment taxes on the compensation you paid to that independent contractor. It's important to note that it's not just the employer's share, but it's also the employee's share of the employment and withholding taxes, meaning that you will be responsible in your audit assessment for the amount you as an employer would have paid over to the federal and state taxing agencies, and also the amount you would have withheld from the worker's check had you properly treated them as an employee. But there are many other potential liabilities aside from the employment tax liabilities if you misclassify a worker, one of which is the right to participate in employee benefit plans. This is an area where we're seeing more claims being made as workers and plaintiffs' attorneys become more focused on the worker misclassification issue. For example, if your company has a 401k plan or offers your employees health insurance, if you have a worker that you're treating as an independent contractor and they claim that they should have been treated as an employee, they can also bring a claim that they should have had the right to participate in your health insurance plan or your 401k plan, but they weren't given that opportunity because they were treated as an independent contractor. Other substantial potential liabilities include wage and hour obligations, overtime obligations, meal and rest period liabilities, unemployment insurance, those type of things. So there are a lot and very significant potential liabilities that accompany worker misclassification. Let's talk a little bit about how this issue typically arises. When you start using an independent contractor, a lot of times, as Tom referenced, the worker himself or herself may have requested that status. And the company, because of the benefits that we discussed, may be happy to accommodate the worker. So why and how would the worker misclassification issue arise? Well, in my practice with employment tax audits, where I typically see it arise is when a worker that has been treated as an independent contractor files an unemployment claim. This may happen because your business declines and you no longer need the services of your independent contractor, or perhaps you become dissatisfied with the services they're providing and stop using them. That worker then, if they can't find other work, oftentimes goes down to the unemployment office and files for unemployment benefits. The unemployment office will then assign someone to look at that case, and that person, that auditor, will make a determination on whether the worker was appropriately treated as an independent contractor or should have been more properly characterized as an employee. If they decide that they should have been properly characterized as an employee, what generally will happen is they will make a referral to their audit department, and it's very likely that your business may be audited. There are other ways that the issue can come to the attention of various agencies, of course. If you have a worker that's been injured that has been treated as an independent contractor, he or she may file a claim for workers' compensation or may file a disability claim, claiming that they should have been treated as an employee and they're entitled to these benefits. Another area where we have seen that there has been an employment tax audit triggered is where a business has a substantial change from year to year in the number of 1099s that they issue. There's nothing inherently wrong with having a change in the number of independent contractors you use, or even a significant change from year to year, but we have been informed that this can trigger an employment tax audit. Then, of course, there's always your disgruntled worker that goes and files a wage and hour complaint based on the fact that they believe they should have been treated as an employee, perhaps files a Form SS-8 with the IRS, which is a request that the IRS make a determination on their employment status. And finally, there's always the risk that one of your competitors may make an anonymous complaint to a federal estate agency that you are improperly characterizing your workers. How do you know if you've properly classified your workers? Unfortunately, there is no statutory definition of independent contractor. The various governmental agencies, federal and state, and between the states, all seem to apply different tests. They call them by different names. However, in substance, while the tests have different names and somewhat different factors are structured differently, the tests are very similar. For example, the NLRA uses a principles of agency law test. The IRS has a multifactor test that we will discuss in a bit. Under Title VII and the ADEA, there's a hybrid right to control and economic realities test. And then the FLSA, FMLA uses the economic realities test. When the IRS looks at a worker's status, this can come up either when a worker or a company sends a request to the IRS to make a determination of the worker's status. It can also come up during an employment tax audit. The IRS used to have a pretty well-known 20-factor test that was used to determine whether a worker should be treated as an employee or could be treated as an independent contractor. Some years ago, the IRS changed this test. They changed the structure, perhaps not the substance to any real degree, but they changed it to a three main factor test. And those 3 factors are behavioral control, financial control, and the relationship between the parties. Those are the 3 main areas that the IRS will look at in making a determination on the status of a worker. There are a number of factors that they look at under each of these areas, which we will go through, but it's important to keep in mind that those factors are analyzed on a case-by-case basis. There is no one factor that is going to be determinative of the issue on whether your worker is properly categorized. Some factors can carry more weight, some less, but all factors are considered. The first broad category that the IRS will look at is behavioral control. The general way you should look at behavioral control is that the IRS will look at when, where, and how the worker is performing the services. Are you, as the company, telling that worker when, where, and how to perform the services? In looking at this, the IRS will look at the type of instructions that you give the worker. Are you telling the worker how to do the job you're giving him? Are you telling him the details of the job as opposed to the final result that you would like the worker to achieve in performing the services? The IRS will also look at the ability to hire assistants. If the worker who has been being treated as an independent contractor can hire assistants, that leans towards a finding of independent contractor status. And along with that, who chooses the assistants that the worker hires. One reason this is an important factor is because it shows that the independent contractor is, in fact, operating his own business, has fixed costs, is marketing. It indicates that he is marketing his business to the public as well. Under behavioral control, the IRS will also look at who purchases the supplies and services, and if it's the independent contractor that purchases the supplies necessary to perform the job, who tells them, who determines where those supplies are purchased from. If the employer instructs the independent contractor where to purchase the supplies, that's indicative of an employment relationship. If the independent contractor makes that determination and has control of what and which supplies he or she purchases, that's more indicative of an independent contractor relationship. And then another thing the IRS will look at under this behavioral control test is whether the work needs to be performed personally or whether it can be performed by one or more persons. Another important thing that the IRS is going to look at under behavioral control is training. Do you as a business train the worker that you're treating as an independent contractor? And this makes a lot of sense because the independent contractor should be in the business of providing these services. They're operating their own business. They therefore should have the training necessary to operate that business. If you as an employer are required or even do give any training to the worker, it's going to be a factor that can make the finding of independent contractor more difficult. The next broad category that the IRS is going to consider is financial control. And again, this goes down to the fact that the IRS wants to see that the independent contractor truly is operating his or her own business and has the financial risks and benefits that go along with operating your own business. Under this broad category, the IRS will look at who is providing the supplies and equipment. They'll look at this again. Is the independent contractor having to pay the costs of the supplies and equipment, or is the employer providing those supplies and equipment? Very importantly here, an example would be a truck driver who is providing his own truck. He has a substantial investment in his equipment, and he is in the business of operating that truck and providing trucking services. If you look at a trucking company that owns the trucks and provides the trucks for the driver to use, the IRS would consider that to be a factor leaning towards an employment relationship. Office space is another factor that the IRS will look at under financial control. Ideally, if you are using independent contractors, what you'd like to be able to show is those independent contractors aren't coming into your place of business for the most part to provide the services, unless there are outside reasons why that is necessary, but instead they're providing their own office space, whether it's a home office or a fixed office, but they're providing their own office space. It's beneficial if you can show that they actually have an outside office and they have a fixed lease payment, because the IRS wants to see that there is a financial downside and upside that that independent contractor can incur in operating this business. And fixed costs like office space or lease payments go towards the financial downside of operating a business. Again, the IRS will look at, does the worker have unreimbursed business expenses? This is an important one to keep in mind when you're drafting your independent contractor agreement. To the extent possible, have the independent contractor be responsible for the business expenses that he will incur in providing the services. Another important factor under the financial control category is whether the independent contractor is marketing his or her services to the public. You can show this by showing that the worker has perhaps filed a fictitious business name statement, has business cards, has a website perhaps, has other marketing events, and markets its services to the public. These are all important things that you want to show in an employment tax audit. The IRS will also look at how the business pays the worker, and again, all these things really go into the opportunity of the worker to realize a profit or loss. The final broad category that the IRS is going to look at is the relationship between the parties. One of the things that the IRS will look at here is whether there's a written contract between the company and the independent contractor for the services that are going to be provided. The written contract is and can be an important thing for both sides, for both the agency that is looking at the classification issue and for the employer. The employer wants to show that there's a written contract that has all the right terms in it, that reflect that the independent contractor can work for others, that he or she provides the equipment and supplies necessary to perform the services, that he or she can hire workers, those type of things, all the factors we just talked about. The IRS or the agency that's looking at the issue will look at that written contract to see, does it provide that there are required meetings of this worker? Is there any training that that contract looks at and requires the worker participate in? So the contract, while it's not certainly a determining factor in this analysis, the terms of it can be very important. Going back to employee benefits, it's important if you're treating a worker as an independent contractor that you not provide them employee type benefits such as sick leave, vacation leave, the right to participate in your employee benefit plans, because these all are things that agencies will look at and point to in claiming that your worker should have been treated as an employee. The permanency of the relationship, really the length of time that that worker has provided services to you, is a factor that has become increasingly important in this determination, and we'll talk about that a little bit in later slides. And then the extent to which the services performed by the worker are a key aspect of the regular business of the company or are an integral part of the company's business has also become a very key factor in this determination. I'm not going to talk a lot here about IRS Section 530 relief. What I do want you to take from this is that if you go through an employment tax audit and your workers are reclassified as employees, if you go through a state employment tax audit and your workers are reclassified as employees, you need to know that may not be the end of it for federal tax purposes. The IRS does have a safe harbor that protects businesses from an IRS challenge to misclassification if certain tests are met. Those being that the company had a reasonable basis for treating the individual as an independent contractor, the business has consistently treated all workers in similar positions as independent contractors, the business has filed all required returns, being their employment tax returns, Form 941 and 940, and they've provided 1099s to the workers in the manner consistent with their treatment of the workers as independent contractors, and that the business has relied on a long-standing industry practice in making the determination that they would treat these workers as independent contractors. There are a few things that I see with clients that tend to be some risks and pitfalls that I just want to raise. One is corporate officers. The IRS and some states will treat corporate officers as what we call statutory employees, meaning that if the corporate officers are providing services to the company and receiving any compensation, they're automatically considered to be employees of the company, regardless of the factors that we just talked about. So look at your corporate officers and make sure that you are treating them as employees, because that is an area where the IRS and state taxing agencies will also always look at in an employment tax audit. Also, at least in California, if you are a licensed contractor, if you use unlicensed subcontractors, those unlicensed subcontractors are automatically deemed to be your employees. And that's another another area like corporate officers that will always be looked at in California in a state employment tax audit. We talked a little bit about length of service, and the two cases listed on this slide, Cromwell and Thibault, really go to the increased focus on length of service. In Cromwell, it was a case where when you look at the factors, you think, of course, these plaintiffs should be treated as independent contractors. The case was one where the plaintiffs, the workers, were trying to recover unpaid overtime. They were splicers that worked on telecommunication line repair after Hurricane Katrina. They didn't receive any training. The company generally didn't have control over how they performed the work. The plaintiffs had a substantial investment in their equipment that they used to perform the services. They provided their own trucks, testing equipment, tools, etc., but yet the court found that they were employees. And what the court focused on is the fact that these workers worked continuously for 11 months for this one company, and they didn't provide services for any others during that 11-month period. Based primarily on that fact, the court again made the determination that these people were employees. Conversely, in Thibault, that had very, very similar facts, the workers only worked 3 months for the employer, and the court found that they were independent contractors. So the longevity of service can be a significant issue.
Next, we're going to talk about some cases that have been in the news, particularly as it relates to Uber. And this is an interesting situation because the drivers who perform services for Uber were considered to be independent contractors. And Uber took the position that it's in the business of providing a technology platform rather than providing transportation services. And this is a pretty critical issue in the case because the drivers said, look, we drive. Uber's in the business of transportation, and we are doing things as Uber directs us to do. We should be considered employees. We rely on this for our livelihoods, and Uber is at the heart of what we do to earn our wages. Uber says, we're not a transportation business. All we do is we provide an app. It is a platform essentially to broker private transactions rather than to supervise, direct, manage employees who would happen to be drivers. Now, this issue went before the California Labor Commission, and the labor commissioner found a former driver to be an employee entitled to wages and the other rights of an employee, and found that this employee driver was an integral part of Uber's business, obtaining passengers to provide rides, and that driving was a fundamental part of the Uber business rather than simply a technology platform. The labor commissioner relied on factors from a California case known as Borrello, and what they looked at included Uber's vetting prospective drivers, essentially a screening process, restricting which vehicles could be used, providing drivers with a smartphone app in order to conduct business, monitoring the drivers' approval ratings, and telling the drivers they could not negotiate fees. Additionally, there's the O'Connor case involving Uber, which was in federal court rather than the labor commissioner. And there, a federal court judge determined that Uber drivers could together move forward with a class action lawsuit on the basis of misclassification, employee status, and that they could pursue back wages, sick leave, expense reimbursement, and participation in employee benefit plans. So these are live issues, and certainly something that courts and agencies are going to look hard at. It's important to remember that under the law, the benefit of the doubt often goes to the employee or the person alleged to be or alleging to be an employee, and the burden is often on the business to show that an individual is an independent contractor rather than an employee. Lyft, another company which has a business model similar to Uber, is facing similar issues with its drivers, and we should expect that cases will continue to emerge where the rules will develop on how the individuals working in this environment are considered, the rights they have as employees or independent contractors. In July 2015, the Department of Labor, the U.S. Department of Labor, provided some guidance on whether an individual is an independent contractor or an employee under the Fair Labor Standards Act, FLSA, and DOL said that they would use a broad economic realities test, which we will be talking about. This is very important because the issue of control is less a factor, and what is more emphasized is whether a worker is economically dependent on an employer. If this is where you earn your livelihood, if this is where you spend your time, if you are performing services that are an integral part of that employer's business, you are more likely under this analysis announced by DOL to be an employee rather than an independent contractor. So let's talk a little more about this Department of Labor economic realities test to assess whether a worker is or is not properly classified. DOL is going to look at the degree to which a worker's work is controlled by the organization. Are you as a business telling this individual what they need to do and how to do it? Secondly, what is the worker's investment in facilities and equipment, if any? Does the worker purchase the equipment that he or she uses? Does the worker decide which equipment he or she will deploy to perform services? What opportunities for profit or loss are there? In essence, is this individual running his or her own business, or is the worker dependent upon the employer to earn a profit or loss, which will govern the success of the business enterprise? What amount of initiative, judgment, or foresight does this individual use in open market competition? If this individual purely drives a truck for one company and does that in all the hours worked, it's more likely that that individual is an employee of the trucking company. If, on the other hand, the truck driver is marketing services to different companies, providing services, and available to accept or reject assignments as he or she sees fit with a particular company or companies, that individual is more likely to be an independent contractor. Permanency of the relationship, as Cindy mentioned, is very important. If you have someone who is working all the time, 52 weeks a year for one company, they are very likely an employee. If they go from place to place as the need and job opportunities arise, they are more likely to be an independent contractor because they have that movement and that lack of permanency of the relationship. Number 6 is very, very important. And I think that this is maybe in the cases I'm seeing the hottest issue that I'm dealing with. Whether and to what extent the worker's work is an integral part of the organization's business or activities. I often use the example to illustrate this. If you are in a truck driving business and you drive a truck, you are part of the business purpose. If you are, on the other hand, a trucking company and the person at issue is a plumber who comes to fix the sink, you are more likely to be an independent contractor. The trucking company is not in the business of unclogging sinks. A plumber is. And so the plumber comes, does the job, and leaves, determines how many people are needed, what equipment to use, what time to show up, and how to do that job. You show up, you do it, you leave. That is an independent contractor, rather than someone who is there to perform services, the nature of which that business exists to provide those services. Also, in looking at whether a worker is properly classified, we want to look at state factors such as those provided by the California Division of Labor Standards Enforcement, or DLSE as we call it. And in that Borrello case, which I mentioned earlier, which is cited here, an individual will be considered an employee where the employer exercises all necessary control by direct or indirect means over the work details of the individual. So it may be you or your management team telling the individual, this is how you're going to do it, or by the circumstances, the implied control, indirect means over the work details of the individual. That could be based in just the day-to-day of how you do business and what people understand to be expected. And that could be interpreted as indirect control. Another factor to consider is contractual language. I would tell you that it is very unlikely that simply by writing in a contract that an individual is an independent contractor, that would make them an independent contractor and immunize you from the possibility of a misclassification claim. Contractual language alone will not determine the independent contractor relationship. It is something that is far more complicated than that. And as noted on this slide, there is no single definitive factor in determining whether an individual is an independent contractor or an employee for purposes of wage and hour laws, or for that matter, any other laws, taxation, or other labor and employment laws. And I'll turn it over to Cindy for the next portion.
So let's go through the various factors and compare how an employee and an independent contractor would be treated under each of them. First of all, the personal service factors. Is the worker required to provide the services personally, or can they hire others to assist? An employee generally is required to render the services personally, and an independent contractor has the ability to hire others to help provide the services. In tax audits and when you get scrutiny from other governmental agencies, I will tell you that this can be a significant factor if you can show that your worker is hiring others to provide some of the services that you contracted with that worker to provide. That can be a very significant and favorable factor for your business in terms of the classification of your worker. Hiring helpers, if the worker hires, pays, and supervises those helpers, that's great. That leans towards a finding of independent contractor. You can have a worker, however, that acts as a foreman and supervises others, but if the workers that they supervise are paid by the employer, then that's not going to be beneficial. That will tend more to lean toward a finding that the worker is an employee of the company. We talked a little bit about the continuing relationship in the Thibault case. Employees tend to work for a company for a number of years, for a longer period of time. Contractors tend to be hired to do a limited job or a project and move on to another project, perhaps with another company. With respect to hours of work, contractors should be able to determine when and where they will perform the services. They should be able to accept and reject jobs that are offered by the company. They can choose what days or hours they're going to provide the services, with certain limitations if there are outside circumstances that require, perhaps on a construction project, that the contractor provides services at a certain time. Employees are obligated to work the days and hours that they're assigned by the employer. Full-time, while there are employees that are part-time and full-time, if you have a worker that is providing full-time services to your business, that can tend to lean toward an employment finding. An independent contractor would typically have multiple jobs ongoing at any one time with a number of different employers. Location goes to who determines where the services are being provided. A contractor should be able to work from their office, work from their home. They determine when and where they're going to provide the services. An employee typically is told that they must perform the work either in the office or where they are allowed to perform the services. The order of work also goes into the determination. An independent contractor should really be able to determine how the project is done. They're told what the ultimate end project should be, and they determine the order and how it's performed. An employee is more typically supervised in the order of how they are performing their services. Reports can be a key factor that agencies look at when they're looking at your worker classification issue. If a worker is required to turn in reports to the company on the work they're performing, the progress of that work, it tends to indicate that the employer has control over how the services are being performed. Contractors are typically not required to submit periodic reports. There can be situations where that can happen, but it's not typically thought of as a factor that would go towards a finding of independent contractor. Payment frequency, I don't see this as raised as much by various agencies, but if you're paying your independent contractors without them submitting invoices and paying them as you pay your employees, it can go against a finding of independent contractor status. Travel expenses and tools, these are both things that if you have workers that you're treating as independent contractors, you want them to be providing those and paying for their own travel expenses. Employees typically would be reimbursed for their business expenses, and the employer would furnish the tools that they need to provide to perform the services. And again, investment in the business, an independent contractor is a person that is operating their own business. So they would typically have an investment in that business, whether it be in substantial equipment necessary to perform the business, leased office space, employees, some type of fixed investment in that business. Maybe it's in marketing supplies, but some kind of investment in their business. And that goes into the profits and losses issue as well. Because they have an investment, they have the ability to generate a profit, but they also have the risk of a loss in operating their business. Multiple jobs, it goes a little bit back to the Thibault case. A contractor is thought to work for more than one client at a time, while employees typically will only work for one employer. And going to availability, contractors tend to market their business to others. You want to be able to show that your worker that you're treating as an independent contractor is trying to get clients and is marketing their business and working for third parties. The right to discharge and right to quit are typically they're typically factors that are considered. They don't carry as much weight in today's analysis of whether a worker is an independent contractor or an employee, but they are part of the factors.
Next, we are going to talk about some tips in summing up the information that we've covered. And for any business, any employer looking at the possibility of using independent contractors or looking at an issue of misclassification, it's important to conduct a comprehensive review of current employee classification systems. Look at who you have, how you use them, how you designate them. Where you have independent contractor relationships, consider the factors that we have talked about and assess whether it really is a proper classification. It's important to look at what goes on in your industry and to see position classification standards and best practice guidelines. Just because someone down the road does it a certain way doesn't mean that it's proper for you to do it. However, if there is a standard practice for your industry, something that has been established over a period of time, maybe there is an argument that someone is more properly classified as an independent contractor than they might be in the ordinary court. Implement internal reviews to prepare for audits and employee litigation. You want to make sure that you have control over these issues to be able to assess them and to look at the risks as well as the benefits of how you classify different individuals. If you have written independent contractor agreements, you want to make sure and review the language that is there to see whether there are any potential pitfalls in the documents you use. Have there been any legal issues involving the types of language and clauses that you use, which might warrant some adjustment? You may want to consider using records of hours worked, even for people designated as independent contractors, to aid in potentially defending against large lawsuits. If you have a wage and hour lawsuit, you may be aware the benefit of the doubt goes to employees if you do not have records. So some sort of backup, even if not a full-on payroll record, could be helpful. And if you have any questions, of course, you want to consult counsel experienced in these issues. In connection with independent contractor agreements, if you're putting this in writing, as I think is often appropriate to formalize what the relationship and expectations are, describe the nature of the services and clarify that it is not an employment relationship. It is an independent contractor relationship. Acknowledge that the individual, the independent contractor, has the right to work for others and to do his or her own hiring of assistants. Identify the parties as contractor, consultant, or agent in the agreement. Make sure to avoid use of terminology like supervise or training. I've been in the position of defending companies who have had agreements and spoken of supervision, who have inadvertently referred to independent contractors or people they allege to be independent contractors as employee. You don't want to have that back and forth, which creates vagueness. And again, the law, more often than not, the benefit of the doubt goes to the worker, and the burden of proof more often goes to the company. Provide in the agreement that the contractor will not receive employee benefits so that there is no vagueness or confusion over that issue. And include provisions which describe the independent contractor's ability to control the manner and means of performing services and setting one's own schedule, so that there is not the sort of control that you might expect of an employee relationship. The judgment and the decisions are up to the contractor. You want to have an indemnity provision regarding employment taxes so that if a claim does arise, the responsibility goes to the independent contractor. You want a term and method of payment, which may vary from what you have and should vary from what you have with an employee. Establish who is responsible for providing equipment. If it's a truly independent contractor sort of relationship, it would be the contractor. And you want to confirm responsibility for reimbursement of costs. As Cindy mentioned, you reimburse employees, you pay for the job with contractors. You want to lay out those expectations and terms. And finally, you want to make sure that there's reference possible to incorporation of that independent contractor's business, a fictitious business name by which that individual sets him or herself out as a separate, distinct business who could properly be considered an independent contractor. Well, this concludes our program for today. If you have any questions, please feel free to contact either Cindy or me. Our contact information appears on this slide. Thank you and have a good day.